All persons having business before the Honorable Associate Judges, now presiding over District of Columbia Court of Appeals, draw near and give your attention. God save this United States and its on court. This on report is now in session. Please come to order.
Good morning and welcome everyone. The COVID-19 pandemic has required us to make a lot of changes. Although the court is working and deciding cases, we are now having oral arguments remotely. Those arguments are being streamed live on YouTube and they're available thereafter, and the links to view them are available on the court's website. The court staff has been working hard to try to get the judges and counsel ready to conduct remote arguments, but technical problems may arise, and if they do, we ask for patience. We have two arguments on this morning's calendar. I want to mention at the outset that Judge Stedman is recused from the second of the cases, and he's been replaced by Judge Nebaker. So after the first argument is finished, we will take a brief recess, and then Judge Nebaker will replace Judge Stedman. Turning to the first case, the first case on the calendar is Sergio Velasquez Cardozo versus United States, number 17 CF 774. Counsel, you may proceed.
Good morning, Your Honor. My name is Matthew B. Kaplan. I'm, as you said, appellant for Sergio Velasquez Cardozo, and I respect, if it's okay with the court, 6 minutes of rebuttal time. Your Honor, so let me start with the substantive kidnapping issues. It's undisputed in this case that under the facts of this case, the government must prove both a seizing and separately and independently a holding and detaining. In our view, these concepts require some dominion and control over the person, over the victim. That did not happen here. The victim ER's forward motion was briefly impeded. It was stopped, according to the police officer witness, for a quote split second. According to ER, the contact between the assailant and the victim lasted quote moments, and the victim shrugged the assailant off and continued to walk forward. Shrugged is the word of the victim. We have cited several dictionary definitions, which we think we get to the issues that what does the words seizing and the words holding and detaining mean. We cited several dictionary definitions, and we've also pointed to the suggested that the Fourth Amendment case law might be a useful guide to what.
Mr. Kaplan, can I ask you about the Fourth Amendment case law analogy, because if it's a useful guide. And we're focusing on cases like California versus Hood RED and what's said there. Why would this not, if a police officer walked up to someone who is, going about his or her business and who the police officer suspects of criminal activity and ran up and bear hugged, is unable to walk, although briefly, why would that not be a seizure under Fourth Amendment purposes that would be completely unlawful unless there was the kind of justification that was required?
First of all, you dropped that slightly there, Judge McLeese, but I think I understood your question. It's not, obviously, we suggest that we could look, the Fourth Amendment case law can be looked to as a guide, but it's obviously not a direct analogy. I mean, the most obvious difference is a police officer is armed. A police officer has the authority of the state behind them. When a police officer, I think the point we're trying to make is the Fourth Amendment. One of the Fourth Amendment test is, does the individual feel free to leave? And if a police officer,
let me ask my question a little bit differently. Assume we agreed with you that the Fourth Amendment is a good analogy. Mm-hmm. Do you think what happened here was a seizure for Fourth Amendment purposes?
No, I don't. And again, it was not a police officer. It was, in fact, she didn't know who it was. Someone reached around her and grabbed her.
That's certainly true. Had it been done by a police officer, would it be a seizure?
It would be different. And one thing, Your Honor, you mentioned the word bear hug, and that does. I mean, the police officer, actually, it's a former police officer at the time of his testimony, used the words bear hug. But I think, to me, bear hug implies a firm grasp. But I think it's clear from his testimony that's not what he was saying. In fact, what he actually said in his testimony was that he thought these were like, it was a very quick hug, and he thought there was like two friends, would exchange a hug. And what he thought was very strange is immediately after this hug, the assailant turned and walked away. So it was a very brief, fleeting, non-forceful contact.
So, I mean, I guess, could you just articulate what the test is for when something rises to the level of when somebody has been held and detained? Is it that they have to, at least for a moment, think they can't get away? What would what would a jury instruction look like in your view?
First of all, I think the most important point is there's something more than would have happened here. And I think that may be an appropriate test, is whether the person reasonably thinks that they're detained. The person thinks that they're free to walk away, which the victim here did, because she did, in fact, walk away. Some meaningful.
Well, can I ask you, I'm not sure that's quite right.
Mm-hmm.
Let me just ask you, I don't
Sure.
want to interrupt your answer to Judge Field's question, but just on the factual point you're raising, I thought the evidence was that the victim had to use force of her own, or I don't know about had to, but did use force of her own by throwing her elbow back or pushing her elbow back or shrugging her, some force of her own in order to, but before she was able to then resume walking. Am I misunderstanding the record, or?
Well, Your Honor, the word that she used was shrug. I quote unquote shrug. I shrugged him off. And
well, again, we do need to view the evidence here in the light most favorable to the verdict. And so there were other terms, including throwing elbows back and the like, that might sound perhaps more favorable to the jury's verdict.
Again, I think if you look at the entire, it's not very long, the entirety of the victim's testimony is someone reached around her, and because of the fact someone reached around her, she was stopped her forward progress was implemented, was impeded for a moment, and she kept on walking. In our view, for kidnapping, for the detention, the seizure, for holding and detaining and seizing for kidnapping, it's got to be something more meaningful than that temporary, transitory impedance of her forward progress. I mean, what really happened here is she was, I think, even interpreting the evidence most in favor of the government, is someone reached around her and touched her in a very inappropriate way. But there was no force, there was no detention, there was no holding under the facts.
I wanted to wrap back around to Judge Beal's question, because it's hard for us to write an opinion that says we don't know what the law is, but it requires more than what was here, because this was, in one of the words, appreciable, not appreciable. We really would want to ordinarily give better guidance than that. And one of the issues, there was a time when we had a body of law where we did try to grapple with those and have ideas about, well, was it incidental, did it increase risk? And part of the reason, for better or for worse, one could agree with this or disagree with it, the court ended up kind of abandoning that line, was it was very hard to figure out how to administer the test. And so if we are requiring more than transitory seizure, more than transitory inability to move freely, can you give us any help about how we would formulate that beyond just saying, more than transitory? The word appreciable, if you look in the dictionary for that, I would have thought this is appreciable in one of its normal senses. The officer and the complainant both were able to detect and perceive that she had been walking freely, and then all of a sudden she wasn't, if briefly. So I would think it was appreciable in one of those senses of that term. So, I mean, are we talking 5 seconds? Or are we talking, what do you have in mind for us to give guidance if we were going to go that route?
I think, we give a Black's Law Dictionary of seize, which means to take possession of. And I think there's got to be some exercise of dominion or control over the person, over the individual, which some meaningful, in a meaningful sense. And I think that's what.
Well, this was, I think, very meaningful. I mean, I think this was very meaningful to the complainant, and I would have thought it would be very meaningful to me if I were walking down the street and someone grabbed me in the way that was grabbed here. So I'm not sure the word meaningful is going to necessarily favor your client on the facts of this case, or be very helpful as a test. So again, imagine that this case was exactly like it was, except the testimony was that the bear hug lasted for 5 seconds. Would you say kidnapping sufficient or not?
I think it depends on the reasonable, in part on the reasonable perception of the victim. The victim felt confined and couldn't get away and under
Well,
the
I'm just
control
saying,
of the
imagine
person.
the evidence in this case. I'm saying, imagine the evidence in this case was exactly as it was, except the only additional piece of evidence was, rather than saying, you know, transitory or the various words that were used here, all the temporal words said 5 seconds. But the evidence was otherwise exactly the same, sufficient or not sufficient.
I don't think that would be sufficient to be really for a person to be under the dominion or control of an assailant. But of course, that's not the case here. This is the case of a split second, and really, it's an unconsented touching is what in our view happened here.
Counsel, can you just articulate for me what distinction you're offering from Richardson, where on my reading, the court says, you know, appellants argue that detention needs to be for a prolonged or appreciable length of time. And the court seems to say, we disagree. That is not the test. It doesn't need to be for an appreciable length of time. And so what is your distinction of Richardson?
Well, first of all, I think in Richardson, the focus of the case was on whether it would be kidnapping had to involve some conduct separate and independent from another offense. And I think the length of time, there's some language to that effect in Richardson, which I think is in our view is dicta. But one of the arguments that we've made here in a supplemental brief is that, which I don't think was addressed in Richardson, I don't think was addressed in any of the other court's case, although the trial court focused on it, is whether there was a seizing or a holding and detaining here in the first place. And, you know, it may be true, I mean, assuming for the sake of argument, the most brief of seizings, the most brief of holding and detaining, and we've got to have both those things together, constitutes a kidnapping. But our argument here, at least in the supplemental brief, is there was no seizing and there was no holding and detaining, and therefore you don't have a.
I mean, it sounds like an artificial distinction to me. I mean, it sounds like you're trying to sneak in the back door. A seizure or detention doesn't need to be for any appreciable length of time, but a grab or a hold needs to be an appreciable length of time to constitute a seizing or detention. They sound like, you know, 6 on one hand, half dozen on the other. It sounds to me like an argument that's been foreclosed by those other cases.
Well, I would respectfully disagree. I don't think those cases address the issue of whether a seizing had occurred here. And I think the point we're trying to make is that this brief incidental touching was simply cannot reasonably be construed as a seizing or a holding and detaining. The individual was never seized, she was never held, she was never detained. So you don't get to the issue of did it if that didn't happen, you don't get to the issue of did it last long enough. Let me, if there are no further questions about that, I want to touch briefly on the sex offenses, felony arguments that we make. Our overarching, one of our overarching arguments in the sex offenses cases is that the ASA needs to be looked at as a whole, not independently section by section. You know, it's a carefully laddered, integrated statute. And one of the provisions that most seemingly applies to the unconsented touching in this case is misdemeanor sexual abuse. And in our view, it would be improper to effectively read third degree and fourth degree sexual abuse in a manner that essentially obviates, makes superfluous the misdemeanor offense. As the third degree sexual abuse, in our view, there's no way a reasonable jury could find that this case involved the use of such physical strength or violence as sufficient to overcome or restrain or injure a person. There's simply.
Well, I guess it seems like that's a little I mean, if we conclude for purposes of kidnapping that the evidence was sufficient, that there was a seizure and holding and detaining, then would it follow that there was a use of force that meets the definition for purposes of third degree because there would have been force that was sufficient to detain because there was in fact detention? So are they sort of tied, or do you think that somehow it's possible. Do you think the concepts of detain are different for kidnapping and for third degree, the third degree offense?
I do think there's a difference. I mean, the definition for third degree requires physical strength or violence, which I don't think there's any evidence of here. And I think you could have a kidnapping without the use of strength or violence.
Right, but so why if I'm walking along and someone comes behind me unsuspecting and bear hugs me so that I can't walk, if briefly, why isn't, again, assuming there isn't a requirement of duration for restraint, then why couldn't a reasonable fact finder find at least that there was the use of physical strength sufficient to very briefly restrain me?
Again, I think I would go to what the testimony actually was in this case, that it was a very brief. Again, I think the bear hug language is misleading, because that's clearly not what he didn't mean. A bear hug in the sense that a bear would actually hug a person. He meant a very brief touching. And
well, bear
that's
hug
what
is figurative anyway. I mean, I don't know that bears hug people. I wouldn't want to get a bear hug from a real bear for sure. I think that's a figurative expression in all settings, but.
But again, the police officer described it as almost as if a friendly hug. The victim described it as a momentary touching. I don't think that crosses the line into physical strength or violence. Although I don't think it's the exact same test as for kidnapping.
No, if you ask the victim here whether or not she felt that force was used, I kind of imagine she would probably say, yes, she was pretty shaken up by this event. I mean, to have somebody come behind you and suddenly seize you in a bear hug and touch your private parts.
Well, it certainly was an unconsented, under the facts here, if you can show that it was for purpose of sexual gratification, it was certainly an unconsented touching. But certainly, I'm not trying to minimize what happened here, but I don't think the statute encompasses just a mere touching.
Can I ask you about fourth degree?
Yeah, sure.
I know that your view, in essence, is that for purposes of fourth degree, the incapacity or incapability, to be a little more close to the exact term, can't be shown essentially by surprise. And I guess I wonder, I'm interested in your comments on the letter, the case that the government cited in its 28K letter, but just more specifically, if you look at the statutory language, what's wrong with the following view? Viewing the evidence in the light most favorable to the jury's verdict, your client knew and had reason to know that there was no way that the complainant was going to be able to decline participation in the sexual contact that he planned. He was going to run up behind her and grab her from behind and touch her on the breasts and the buttocks without her even knowing that he was coming. Why doesn't that, in sort of ordinary language, mean that your client, again, a reasonable jury could find that your client knew or had reason to know that the complainant was not capable of declining participation in that conduct, because she was never given an opportunity to do so. She had no possibility to do so. What's wrong with that as a matter of kind of ordinary language?
I think, for one thing, I think the statute needs to be interpreted as a whole, and I think you can certainly envision cases of unconsented touching where maybe the victim has the capacity to say no. But I think if you adopt the government's,
I don't think that's remotely hard. I mean, if somebody started walking toward, I mean, there are millions of cases. There probably literally are millions, but there's certainly thousands of cases where somebody starts indicating that there's about to be some sexual contact, and the complainant says, "No, I don't want that. Don't do that," and then it's done anyway. That's probably. Although there are plenty of times where it doesn't happen that way and there is no notice, that it seems to me that at least as common probably is a setting where the complainant is aware that there's imminent sexual conduct. It would have been capable of declining, or in fact did decline, and the defendant persisted anyway. So I don't know if, to the extent you're suggesting that incapacity by surprise would somehow make every non-consensual sexual touching fourth-degree sexual abuse, I'm not sure that seems obvious to me In fact, it seems not obvious to me, but I don't, feel free to try to persuade me otherwise, but I would have thought there are, you could read hundreds of cases on Westlaw where there not only was the opportunity to decline, but there was in fact a declination of participation in sexual contact.
I would point your honor to the there doesn't seem to be, our position is consistent with the case law in this jurisdiction. My understanding or my reading of the case is this statute has only been applied where there's some disability on the part of the victim, and as we say in our brief, that's consistent with the federal case law as well, where the federal courts have interpreted this term incapacity to mean some kind of incapacity on the part of the victim. And I get our view is that this is fundamentally different.
Can you remind me whether you had pointed us to any cases that expressly say, the government has proceeded here on a theory of incapacity by surprise, and that's just not incapacity under our statute. Did you find cases that hold that, or is your point, not an irrelevant one, but a somewhat weaker one, which is when you look at the cases that that you found, they all seem to involve more where the incapacity is in the condition of the complainant rather than in the situation, more broadly. Is it the latter, or are there actual cases you're aware of that have said?
No, it's
not incapacity.
It's the latter, and I think it's the function of that. I mean, the reality that cases like this do not get prosecuted under the DC statute or the federal statute that this case was prosecuted under. I mean, we've cited a number of cases, and that seems to be the consistent view of the federal courts, is that you look at whether the victim has an incapacity, and I think that makes sense and is consistent with the statute. But you're correct, Your Honor. I think because the situation doesn't usually come up, we don't have a case that specifically says what you're asking if we have a case that along those lines. I would just.
Do you want to comment on the case cited by your opponent in the 28K letter?
Yeah, I believe the case arising from Missouri, and I don't think that's terribly relevant. And it's, for one thing, it's almost over 100 years old. It refers to a totally different. It refers to a rape statute, and as I understand the holding of that case, it was that a doctor who the issue is consent, and the doctor who essentially covertly raped the victim during a medical examination, whether there was consent there under the 100-year-old Missouri rape statute, and the court said there was no consent. So I don't think that case has any significant relevance to this case that we're dealing with today.
I know you're over time, but I did want to, before we finish up, and we'll give you a little bit of time to rebuttal also, I just wanted to hear you quickly on the merger of third-degree sexual abuse and fourth-degree sexual abuse. And I had a specific question at the outset about that. Do you agree that in trying to analyze that question, we should be applying the Blockberger test, where we look at the elements of third-degree sexual abuse and we compare them to the elements of fourth-degree sexual abuse, and we figure out whether each of them requires proof of something that the other does not?
I think it's settled in this court that the Blockberger test needs to be used, yes, Your Honor.
And if you were going to, just briefly summarize, why is it you think that? Can you give me an example? Maybe the easiest way to do this is just give me a concrete scenario where you think, here's a case where the defendant. It's very easy to find cases where the defendant committed fourth-degree sexual assault but did not commit third-degree. But your view is that there is no way a defendant could commit third-degree sexual abuse without committing fourth-degree sexual abuse as well. Is that right?
Well, that was prior appellate counsel made that argument in the opening brief, and we stand by that argument. Yes, Your Honor.
And I guess I have just one concrete question about that. So, if you look at third-degree sexual abuse, one way of committing it, it's option 2, is by essentially threatening the victim that if the victim doesn't comply with the sexual contact at issue, some other person will be subjected to death, bodily injury, or kidnapping. So that's one way you can commit third-degree sexual abuse. Fourth-degree sexual abuse expressly excludes that as a way you can be found guilty of fourth-degree sexual abuse. If you look at subsection 1, it says, you can violate it by threatening or place the other person in reasonable fear, other than by threatening or placing that person in reasonable fear that any person will be subjected to death, bodily injury, or kidnapping. And so it seems like this is kind of a quirk of how these statutes are written, but that seemed at least one way in which one would have committed third-degree sexual abuse, but couldn't have be found guilty of fourth-degree sexual abuse because that's just excluded categorically from fourth-degree sexual abuse. Do you have a reaction or thought on that?
I think I think, let me put it this way. I think we'll stand on our briefs on that point.
All right. Okay, well, we'll give you a few minutes in rebuttal, and we will hear now from the United States.
Good morning. May it please the court, Nick Coleman for the United States. I'd like to begin by addressing the kidnapping arguments before proceeding to the sexual abuse arguments. And what I hear appellant making here today are essentially two arguments as to why there was insufficient evidence of kidnapping. The first is sort of a factual challenge in arguing that somehow this victim was not in fact seized and detained. And then the second is that even if she was detained, that it somehow wasn't long enough. I think the testimony of both the victim and Officer Stoddard establishes that she was in fact detained. If you look at that testimony, Officer Stoddard uses the term bear hug. He says that at least for, as he says, at least for a split second, that she wasn't able to keep walking forward. The victim also says that in the moment that she was grabbed from behind, she couldn't walk forward. And she did have to use force to break free, whether it was shrugging or using her elbows. In other words, she was in fact grabbed, which we submit most people would understand to be a seizure, and she was held. She was held there until she broke free.
Counsel, I want to read from your opening brief, and I just want to see if this is your view still. You say ER was walking swiftly toward her apartment. When appellant grabbed her, he briefly prevented her continued forward movement. That obstruction constitutes a seizure and is sufficient to establish kidnapping. Is that the government's position? That obstructing somebody's forward movement is a kidnapping?
Well, it has to be, so I would submit if by that you mean, Your Honor, just sort of you suddenly step in someone's way and force them to go around you, the answer would probably be no. Here, I think the point is that she was grabbed.
Let me give you a hypothetical. Let's say we're all in the courtroom instead of doing this virtually. And Mr. Kaplan starts heading out and you want to say, nice job. So you brush his shoulder to get his attention. And to stop him, you're trying to stop him so that you can say, hey, good job. In that circumstance, did you kidnap Mr. Kaplan?
No, because I don't think we would call that a seizing. In other words, tapping somebody to get their attention, that's not going to be a seizing. Right. And it's not a holding or detaining.
Let me flesh out the hypothetical, because again, this is language from your brief, where you say briefly preventing somebody's continued forward movement is enough. So maybe it's not a brush. Maybe it is actually a forceful, hey, stop, Mr. Kaplan, I want to talk to you. And you grab his shoulder enough so that he breaks his stride. Is that a kidnapping?
So if I'm grabbing on to Mr. Kaplan and I'm holding him, he's trying to move. And in the moment that I'm grabbing him or holding him, he cannot move. Yes, under the literal terms of the statute, that is a seizure and a detention. And, now, would that be...
Is there a battery that isn't a kidnapping?
So, yes, in the sense that if I punch somebody, I'm not necessarily holding them.
I assume you've obstructed their movement by punching them. I mean, unless they happen to be falling back to begin with and you manage to sneak a punch in there, it strikes me that you've altered their course of movement.
Okay, so I think I understand the question that you're asking me. In this case, the fact that the victim is trying to walk forward, she's grabbed, the fact that she can't move is what shows that she was held or detained.
If she had been sitting on a park bench, no more kidnapping because she wasn't trying to move?
Well, I think if if you're sitting on a park bench and he still comes up from behind and grabs onto her and then holds her, and she has to break free in order to get up off of there, the jury would have enough evidence to find on that testimony.
So you keep,
that
on,
she, in fact,
you keep on layering a second element on, which I agree appears in the statute, but I'm unclear on your view what work it's doing. You said if he grabs her and holds her. I think my question is, what's the difference? Can you grab somebody without holding them? Can you hold somebody without grabbing them?
Again, I'm not sure that in the practical world it is easy to grab somebody without actually holding on to them. I'm trying to focus on what the statute says here and to focus on the elements as they've been written by Congress.
Let's talk about them for a second then. Mm-hmm. So you've got this long list of verbs: seizing, confining, inveigling, enticing, decoying, kidnapping, abducting, stealing, or carrying away, and holding and detaining them. And my question to you is, can you hold and detain somebody? Haven't you read out that first list of verbs or the second? You can't hold or detain somebody without doing one of the various things like seizing somebody in the first part of the statute.
I'm not trying to understand.
Can you seize somebody without holding or detaining them?
I think probably it's hard to do, except in perhaps the instance where your seizure doesn't succeed in the sense that you never actually detain the person. In other words, in the case of me trying to grab Mr. Kaplan, I reach out for him. I'm able to brush my hand on his shoulder, but he's able to step out before my hand can grasp him. In that case, obviously, I certainly haven't held him.
Doesn't sound like
right. What's difficult is, it sounds like you haven't seized him either, unless you're going to use the Fourth Amendment version of seizure, where any touching amounts to a seizure.
Right. So trying to sort of get to, I think what this does show is that there is what the kidnapping statute is designed to do is to say that you have to do one of those things in that first list of verbs. In this case, that did happen. There was a seizure, a bear hug from behind. You also have to hold or detain. That did happen here.
My question, counsel, is having held or detained somebody, haven't you necessarily also seized them? And under that definition, haven't we read an element out of the statute?
No, because you could find some, so again, the other aspects there talk about sort of abducting or enticing, decoying, inveigling. I mean, obviously Congress was trying to be very broad here, talking about how the holding or detention started. Okay, so in other words, they're being very inclusive into how it occurred, because obviously you could entice, a child with candy or something into a van. That's the classic definition of kidnapping of children. And then the holding. Now, you may, in order to continue the holding or detaining in that point, have to make a seizure if the victim tries to get away, then you're going to grab on. But I think sort of the holding or detaining can also, that's why I think the statute also talks about confining, because you might never actually grab onto the person, but you might, if they were in a room with only one exit, stand in their way and prevent them from leaving, and then you hold or detain them in that room.
So is your answer then implying that you think the word seizing in the kidnapping statute requires physical contact, like grabbing type seizing, rather than the kind of seizure you can have in the Fourth Amendment where you stand by somebody with a gun and say, don't move? You think that's not a seizure, but there wasn't physical contact and instead that been under confining?
I think seizure would also, could also occur under those circumstances. I think, really when you read that first list, what Congress is trying to do is make sure that a jury, which has to apply this statute, understands that however the holding or detention started, it's a kidnapping.
They could have just excised the whole list, right? They could have just said, whoever shall be guilty of holding and detaining, or with intent to hold and detain an individual, right? That's your reading of the statute.
Well, that again, I'm not sure, because again, you could imagine juries having some wanting to know, well, when we talk about holding or detaining a person, For example, if I detain a person by, if what I do to Mr. Kaplan on the way out of the courtroom, I know he's got to get to his meeting, but I decide to sort of bore him with 30 minutes of conversation about the case. In colloquial language, you could say, well, I'm sort of detaining him by talking his ear off. But obviously that, unless somebody thought that that was inveigling or enticing, then I don't think that that's certainly a seizing of his person. I think Congress wanted to make sure that there was a sort of wrongfulness or illegality at the beginning of the holding or detention.
I appreciate that. You're giving a. I'm sorry. Go ahead, Judge, please.
Well, I was just. There was a period where this court tried to impose various limits on this statute, and other courts, not all of them, courts are divided around the country about how to address statutes like this. But Judge Deal's hypothetical, and my example was very similar that I had in mind, which is I'm walking down the street and I kind of lose my balance and I grab a hold of the arm of somebody who's next to me, who I don't know at all. I just grab a hold of them and using them as kind of somebody to balance, and that they stop moving because they can't move. And I'm not trying to I have no malign purpose or anything like that. But on the other hand, I grabbed a hold of them and they, I stopped them from moving, if temporarily. It seems like on your definition of the statute, that fits literally. And your point is, of course, no one will ever prosecute that. But it is disturbing, I think. This is a 30-year offense. It's an incredibly serious offense. And it doesn't really have a culpable mens rea requirement explicit in it. It's not like with a bad purpose. It's with intent to hold for ransom or reward or otherwise. So maybe, to use as a balance. And so it's very natural for courts to want to be looking at the words like seize or hold or detain to find limits before a 30-year crime is committed. And it is disturbing and understandable why courts are grappling with this. If your answer to Judge Deal's hypothetical or to mine is, something that seems like totally innocent conduct that people would do would do without a lot of compunction is actually literally a 30-year felony. That's a pretty disturbing consequence.
Right. So I do think that normally when juries are instructed on the kidnapping statute, that they are told that the seizure can't be by mistake or accident. And certainly in general.
That's true. But my hypothetical and Judge Deal's hypothetical, there is that mens rea requirement that's read in as often is that it has to be at least, intentional, maybe reckless, who knows.
Right.
But both Judge Deal's hypothetical and mine, right. But both Judge Deal's hypothetical and mine are directed at settings where, the defendant, without any malign purpose, consciously decides, oh my gosh, I need to hold on to this person. I'm going to hold on to this person briefly, not in any outrageous way, not for any malign purpose, but it seems to be a seizure, very fleeting, and it seems to be detaining or holding, very fleeting. And it is disturbing if your answer is, technically that's a 30-year felony, but don't worry, people won't prosecute you, and if they did, juries would know enough not to convict you. That's an answer, but it's a pretty disturbing.
Well, again, though, but I think that's where we have to invoke another principle that this court has applied, which is to say that where no mens rea is specified in the statute, that the court will imply at least something along the lines of at least recklessness and perhaps something even higher. That's in order to get rid of accidents.
I think Judge McLeese has already tried to, clear that confusion away. Both of our hypotheticals assume an intent to do the thing that you think is holding or detaining somebody. And in my hypothetical, you are very much intending to stop Mr. Kaplan from leaving the courtroom. In Judge McLeese's hypothetical, he is very much intending to grab that person in order to stabilize himself. So I don't know why you keep wanting to say, intent's going to do all the heavy lifting here. We're assuming there's some intent to grab someone. And I think the disturbingness of that being a kidnapping exists even when you say that was purposeful and willful grabbing of somebody. And so I don't think leaning on intent is doing you much good.
So I think 2 points to be made. First is that, although kidnapping can be punished by up to 30 years, it certainly doesn't have to be. There is no mandatory minimum. And so at sentencing, a judge can distinguish between sort of kidnappings, which, in colloquial terms are thought of as incidental or brief or not very significant in setting the sentence. And to some extent, yes, charging discretion does play a role in deciding whether or not a crime is going to be charged. But that's true for every kind of offense. A lot of statutes are broadly worded and could be read to apply to a number of different situations that we might say, well, that seems benign, it seems too much, but that doesn't mean that the elements of the statute have to be rewritten, because it isn't clear that there is either a sort of practical way to do that, nor is it necessarily, particularly when the legislature has spoken about how this statute is supposed to be created, they get to decide what the elements of the offense are.
I appreciate that point, counsel, but let me just try this one more time. If I cross out the list of words, seizing, confining, and inveigling, and all that, and I just say whoever shall be guilty of holding and detaining, and then I also cross out for ransom, reward, or otherwise, that I think leaves me with the statute that you think we have. You think ransom or reward or otherwise doesn't do any work, right? It doesn't matter for whatever reason. If they hold it against somebody, that's good enough, right?
Well, certainly Congress decided to say or otherwise, and right. So they created they've made it for pretty much any purpose. But that's been true of kidnapping, and it would still be true of kidnapping regardless of how long a seizure or detention occurred.
My question is very simple. We can cross out those words, ransom or reward or otherwise, right? Under your reading of the kidnapping statute, it does no work.
So I think, again, you'd have to ask Congress why they decided to write it the way they did. I think the ransom or reward is to make clear that is one purpose. It does.
Why would you make that clear when it can be anything?
Again, I'd have to direct you to Congress as to why they wrote the statute the way that they did.
I don't think you have to direct him to Congress to answer Judge Steele's question, which is true or false. The statute would have the same scope if those words were deleted. That's just a simple true or false. You could explain maybe that, who knows why, but it's a very simple yes or no answer.
I believe that the answer is. All right. So the reason why I hesitate to answer clearly one way or the other is because that isn't the question that's been presented here today. In other words,
actually, it is a question that
has
been presented by judge.
Understood.
It is a question that has been presented by a judge. So I think
right.
I don't know is a good answer, but I'm not sure. I'd rather not answer is a good answer. So if you don't know, that's fine.
I think the answer is I suspect that by putting in otherwise, it has made ransom or reward as a practical matter somewhat superfluous in the sense that it's no longer required for a conviction. I would want, however, I think before making an official statement on behalf of the government as to whether it has plays no role, I would want to look at that, I think, a little bit more clearly.
And can I ask the same question with regard to the first list of verbs? And I will take your reservation that, maybe you need some more time to think about it before officially representing this. But if I just say, whoever shall be guilty of, or of aiding and abetting in, and then I cross out seizing, confining, inveigling, enticing, decoying, kidnapping, abducting, giving away an individual. If I cross out that whole sentence and just say holding or detaining, or with intent to hold or detain, shall be guilty of kidnapping. My understanding of your position is that's a kidnapping in all circumstances, that one cannot hold or detain somebody without checking one of those earlier verbs off. So we might as well get rid of those too.
So I wouldn't, again, to say that I would get rid of it is a little bit sweeping. We've been focused here on whether in this case there was a seizure, whether in this case there was a detention or holding. Now, whether you could construct this as a matter of linguistics in a way to understand holding or detaining, that essentially, because they're going to begin by one of the ways that's described in Congress, maybe you don't need that anymore. I suppose that's possible, that you could write a statute that way. That isn't the way the statute is written. What I'm focused here on today, and as I understand appellants' arguments, they are focused on is whether or not there has been a seizure and whether there's been a holding or detention. And I think the evidence here is clear that yes, both of those occurred. So, and certainly if the argument is that the detention must last a certain amount of time, before there is such a thing as a seizure or a holding or detaining. We submit that there is no support, certainly in the statute for that, and none in this court's case law. Judge Steele, as you pointed out earlier in your discussion with Mr. Kaplan, this court in Richardson has said that there isn't an exception for kidnappings that are momentary. And I think that, that is sufficient to answer the question today. Was there a seizure? Was there a holding or detaining? The answer is yes, because it occurred. It was something that was perceived by both the victim and Officer Stoddard. The jury clearly chose to credit that testimony, and thus there was sufficient evidence to sustain this kidnapping conviction.
Now, Counselor, you're over time, but there are at least two other issues I'd like to hear from you briefly on, and my colleagues may have other areas of interest too. But I'm interested in the sufficiency of the evidence with respect to incapacity by surprise, and I'm also interested in merger of third degree and fourth degree sexual abuse. So if you can quickly touch on those 2 points, I'd be interested to hear your thoughts.
All right. So first, with respect to fourth degree sexual abuse, the question, again, I think, the statute is written to say that if the victim is incapable, essentially, of either declining consent or refusing consent, that qualifies as fourth degree sexual abuse. And the reason why we cited the case from Missouri is not so much because the statute it was applying is on all fours with this one. That obviously isn't the case. It was applying the much older definition of rape before states and jurisdictions like the District of Columbia broke it down into different degrees. But it makes, I think, a very common sense point, which is that if the defendant acts in such a way, by taking by surprise, so that it deprives the victim of the ability to say no or to refuse consent, or just as a practical matter to defend herself, then he has essentially taken that away, and that is a manner in which the sexual offense can be committed.
Seems to me you're confusing two concepts. One is to be incapable, and the other is not to have the opportunity to. And as Judge Please pointed out, every unwanted touching virtually is going to be, under your interpretation, a violation of the statute, of this particular part of the statute, seems to me.
So I guess I didn't interpret Judge McLeis's question that way, but perhaps I wasn't hearing it properly. But as I understand, the point that he made was that, in fact, it is possible to commit sexual touching without doing it by surprise. And I would submit that doing it in that manner, it's still a crime. It's still very bad, but it isn't bad in the same way or as bad as when you do it in a manner that where you give the victim essentially no warning and no ability to essentially communicate lack of consent.
As a matter of ordinary language, it seems to me incapable is kind of an ambiguous term. I mean, if you said about me, is he incapable of doing calculus, which I think I could remember and do at least some of, I would say generally I'm not incapable of it. Now, if you looked at me while I was asleep and said, is he incapable of doing calculus? It'd be like, well, it depends. Not generally, maybe right now. And so what kind of incapability is the statute directed at is in a way part of the question. Is it sort of longer term and sleeping is a good example because there are a lot of cases about sleeping. But sleeping also seems to be, at least although a temporary, condition of the complainant, rather than something that is kind of outside the complainant and really more about the situation more generally. So it is kind of interesting that so far, at least, the parties have directed us only to a Missouri case under a very different statute set of provisions from a long time ago. And Mr. Kaplan's point is, if this is the kind of thing that really is taking advantage of the incapable, then why don't we have cases in DC about it? Why aren't there other cases around the country about it? And in fact, there is more law out there that the parties haven't pointed to, and it's not entirely uniform about how to look at all this. And some statutes are express about it. But it seems as though the language by itself is somewhat ambiguous, and you could think that incapability really means sort of preying on those people who are weak and unable, rather than kind of taking advantage of an opportunity to surprise a perfectly capable person, but you're just taking advantage of surprise. So do you agree that you think ordinary language, the only way to read incapable is to include surprise?
So like a lot of terms, it could be read different ways, but I do, one point I would like to make, because Mr. Kaplan has cited a number of cases applying the federal statute. And I think there's a very key distinction between the federal statute, which is 18 USC 2242(2). There's a key distinction between that and DC's fourth degree statute. The federal statute talks about a person being physically incapable of declining participation in or communicating willingness to engage in that sexual act. So it uses the term physically incapable. The DC statute does not say physically incapable, it just says incapable. Physically incapable, I would submit, could well be read to sort of limit incapability to situations in which the victim is perhaps drugged, intoxicated, asleep. In other words, there's some physiological barrier to being able to either withhold or decline.
It's weird that you go to those examples, because that sounds like mental incapacity to me, not physical incapacity. If they were in the right state of mind, they could very well say no, but they are too drugged up to do it. So that might be the reason why you might not put the word physically incapable in there, is because you want to incorporate mental capacity as well.
Well, but I think that there, on that point, both DC's statute and the federal statute have the same prong about talking about being incapable of appraising the nature of the conduct, which there goes to sort of the inability to understand. Now, whether that could be temporary or not temporary, probably had to be fleshed out. But I think that is a key distinction, nevertheless, the idea of either incapable versus physically incapable. And, the DC statute omitted the term physically incapable. So again, I just don't think that what we have here is a statute that doesn't cover this.
Just so I understand how you read the fourth degree sex assault statute, if this same set of facts happened, except Mr. Cardozo announced himself, that he was facing her, and from 100 yards away, he said, "I'm gonna hug you and I'm gonna touch you, and you can't stop me." And being perhaps a larger man than the complainant, she could not fend him off, and he managed to hug her and grab her. Was she incapable of declining?
No, because there again, I don't think incapable is limited only to the sort of, again, the physical ability to fight somebody off. But in that case, she is capable of communicating lack of consent. She's capable of declining it. There, that's really more of a third degree sexual abuse charge, because there the defendant is using force to overcome or her resistance, or to restrain her while he commits the crime. And I think that does point up, if in this particular case, to use its set of facts, suppose if the jury had decided along the lines of what Mr. Kaplan is arguing, that, well, maybe he really didn't use force to restrain her. Maybe maybe the officer was wrong to say that he was actually bear hugging her. Maybe he just put his hands around her, but he wasn't actually restraining her. But he still snuck up behind her and did that in a way so that she wouldn't know what he was doing until it was too late and couldn't consent. Perhaps the jury might have wondered, well, was force used in this case? And if they had decided, we're not sure, they nevertheless could have convicted of the fourth degree sexual abuse by saying that even if we're not sure whether he used force. Now, we obviously argue that he did, and the jury clearly accepted that he did use force. But they might have decided that in this case, we're not sure if he was using force to restrain, but he certainly did sneak up behind her and did so in a way and used that element of surprise to essentially deprive her of the ability to say no.
Well,
and
we're
I think
really
that,
running out of time, but I
Yes.
did want to quickly ask you about third degree and fourth degree merger. And I had, I guess, two questions. One of which is, are you aware of any statute that we have where we have said that a defendant can be convicted both of X degree and X+1 degree of a named offense? So that, you know, multiple degrees worded in that way. Is that something you've ever seen before, or would this be the first time where we had so concluded?
I personally am not aware of one. That doesn't mean it's not there, since obviously I don't claim to be able to know that. I think one thing to sort of bear in mind is that fourth degree, although they're called degrees, that doesn't necessarily mean that they are lesser includeds of each other. In other words, they can be written in such a way that the elements don't merge. That degree is being used here, it seems to me, to sort of communicate a level of severity as opposed to whether one is necessarily a lesser included of the others.
And the second question I had was, in your brief, if I understand your discussion of kind of how to apply the Blockberger elements test, I thought your brief said, if I'm recalling correctly, that third degree sexual abuse requires use of force, and that was part of your explanation. And that doesn't seem to me a correct premise for the, you know, how you would analyze them. Is that your theory about why it is that they don't merge, is because third degree sexual abuse requires use of force?
Well, certainly the way it was charged in this case, I'm sorry.
Well, we don't ordinarily do. I don't think we ordinarily do merger analysis by the way in which a case is charged, rather than by the the statutory elements of the offense.
Right, but there are subparts to different statutes. I guess I want to just pull up and I apologize, I don't have it right in front of me, the third degree statute. As I vaguely recall, there are, a couple of different ways.
It has four subparts. Use of force is number one, and there are others about rendering people unconscious or the like.
Right.
And is it implicit in your answer that you just gave that you think that the way we should be doing the merger analysis is to look at any particular subpart and say, well, this is third degree sexual abuse force, subsection 1, and we figure out whether that merges with some other, some subsections of fourth degree sexual abuse? Is that how we should be doing it?
I think you do, because a statute can call a crime committed in a couple of different ways an offense, but still call it all the same crime. I think you do have to look at the elements as they, the way that they're charged shows you sort of what the elements, assuming, the charging language doesn't track, as long as it tracks the statute. In this case, yes, force was the element that was charged. It's not that he rendered her unconscious. Okay, so that aspect of the third degree charge was not used, and it was not at issue in this case. But yes, force was the element that was charged for purposes of third degree, and fourth degree involves in our view, the use of surprise, which is how the victim was not capable of providing consent. Those are two different elements. One is not required for third degree, one is not required for fourth degree, and thus under the Blockberger test, they do not merge.
I'm sort of surprised at that. I always thought under Blockberger, you look at the statute, not the subdivisions of the statute. I mean, sometimes statutes you can do it A, B, or C. Sometimes they just have a legal statement that says anybody who does X or Y or Z is guilty of it. You look at all three.
I do want to make clear that I'm not trying to sort of change our approach to Blockberger here. I guess my point is this. The elements of these two offenses don't overlap here completely. Each does have an element that the other does not. And this case, although we normally don't use the facts, obviously it's not a fact-based analysis, but this is a case that shows how you could commit one offense without committing the other, and vice versa.
Okay, thank you, counsel. We're well over time. Unless any of my
Understood.
colleagues have further questions, we'll wrap this up and give Mr. Kaplan 3 minutes in rebuttal. Thank you, counsel.
Thank you very much for your time, and would respectfully urge the court to affirm. Thank you.
Mr. Kaplan, you're muted.
I apologize for that. I'll be brief, Your Honor. Opposing counsel talks about the intent of Congress, and I think that's important. And this statute is under a section of the DC code called entitled Kidnapping. It's a 30-year felony, and I think that needs to be taken into account in interpreting the provisions of the statute. And it simply seems to me inconceivable that Congress would have intended the type of conduct that the government is now contending is covered by this statute to be deemed a kidnapping offense. And I would specifically direct the court to the Supreme Court's case in Chatwin, where the Supreme Court makes exactly this point, that we can't consider that this is a kidnapping statute. And obviously the court was dealing with a federal statute, but the court's point was that we're dealing with kidnapping here. This is a very serious offense, and we cannot have trivial conduct be deemed to be a kidnapping, and that Congress could not have intended that. The government said, I think Judge Deal may have quoted this, but the government says in its brief, the district's kidnapping provision captures all conduct obstructing or forcing the movement of another without their consent. And I don't think the government is retreating from that position. I mean, we cited the example in our brief, someone blocking another person from leaving the subway car. In the government's interpretation, that would seem to be a kidnapping. And our view is that is clearly could not have been what Congress intended. Unless there's questions about any other questions about kidnapping, let me turn just briefly to the incapacity, to the issue of incapacity under fourth degree sexual abuse. I mean, the statute says that the person, for a conviction, the person must be either A, incapable of appraising the nature of the conduct. And clearly here, there's no allegation the victim knew what had happened the moment she was touched. B, incapable of declining participation in sexual conduct. Here, she did decline. I mean, she said no immediately when she was touched, and she walked away. And C,
well, Mr. Kaplan, on that point, I think you might not be chopping the issue up with the sufficient temporal granularity. And there are a bunch of cases that are like this, where someone will be asleep and someone will begin assaulting them while they're asleep, and were unable to appreciate it and decline then, but they wake up in the middle and say no. And cases around the country that take that form, what they say is, well, we're going to talk about the assault at its beginning, at its inception, and there was, offensive sexual contact or whatever the particular statute prohibits, at a time at the beginning where there was inability. It's not a defense that eventually the victim, wakes up and is able to resist, whether successfully or unsuccessfully. So if your client, at the moment of the touching, I think you would agree that there wasn't a practical opportunity for the complainant to express disinterest in having that, or lack of interest in having that contact.
But Your Honor, I don't think it can be reasonably said there was incapacity. When someone is asleep, there's a mental incapacity. You're physically unable to consent. There was no incapacity on the part of the victim. She knew what happened, and she did refuse to consent. She indicated a lack of consent immediately.
Thank you, counsel. We're well over time, and so I appreciate everybody's arguments. We will take the matter under advisement. The case will be submitted. We will now stand in a brief recess while we reconstitute the panel.
Thank you very much, Your Honor.
This court takes a short recess. Court is back in session. Please come to order. Okay, we're getting ready to start the.
Good morning, everyone. Sorry for the delay. We're having some technical difficulties. We're back and we'll call the second case. Before I do that, I will indicate, I mentioned before that Judge Nebaker was going to be replacing Judge Stedman, but Judge Nebaker will be taking the case, the argument on the tapes. So we'll call the second case, which is Gary Youngblood et al. Versus DC Board of Zoning Adjustment, numbers 19AA 294 et sec. Counsel, you may proceed.
May it please the court. My name is Heather Benno, and I represent the petitioners and appellants, property owners, and neighbors at Beekman Place and one other property. Good morning, and I will ask to reserve 3 minutes for rebuttal. This petition seeks review of an order of the Board of Zoning Adjustment granting special exception to allow the expansion of Meridian International Center operations with a new conference center and construction of a mixed-use building with even more event space and between 111 to 115 condo units. To get to the heart of the matter, the ANC 1C08, Ms. Fox Perry, testified at the hearing in this matter regarding MIC's operations. Quote, even though it was anticipated as functioning like a private school, it's functioning as a private event center as much as anything else. In 2017, MIC had 149 events, 87 of which were private rentals, 39 weddings. You know, when that happens, the entire neighborhood turns into a parking lot. Half the time.
Counsel, just so I understand where you're going with this, is your argument that in order to be a school for zoning purposes, it needs to be primarily a school, that it's its primary function, or can that be a secondary function?
It has to be a function, and as the court analyzed in the Neighbors on Upton Street case, the primary issue, or what the court said in that case, far more significant is what the record actually shows about what goes on at the school on a daily basis. So you have to look at what goes on a daily basis at the property at issue in order to determine.
Right, but I think Judge Deal's question is to a degree legal about what is your position about what makes a school can permissibly do. And so I understand, like, one of your broadest arguments seems to be really none of what they're doing is school-like. It's not educational enough in the right way. But then you have, seems like another argument, which is, well, even if some of what they do is schoolish enough, is educational enough to qualify it as a private school, it's doing too much other stuff. And are you, just to draw an example, so can a private school, in your view, consistent with a special use exception, can it have some private events, after the hours it kind of rents out its space and does a little bit of that, but not very much of it? Or can it be only school uses, however you're going to define what a school use is?
Yes, they can have some private events, Your Honor, to address this. And we addressed it directly in the brief, as did the ANC 1C when she said that in one of the prior applications for a special exception, the board found that that the institution was allowed to have the number of dances typical to a regular college. That's not the exact quotation, but I could find it in the record for you if you wanted to see it.
And do you know off the top of your head, and do you know off the top of your head what regulations you think govern the extent to which something that is let's say primarily a school, and therefore let's say an appropriate entity to get a special use exception, how much of that it can do, or what governs the limitations, if any? What regulation do you think governs the limitations that may exist on the ability of something that is to a degree a school to be using its property primarily, largely, exclusively for things that are not school related?
Well, I
do you
think
have a regulation that you could point us to, or?
Well, the regulation that I am relying on is the regulation for the special exception. and the special exception review. So essentially, the BZA is authorized to grant it when it will be in harmony with the general purpose and intent of the regulations, of course. And secondly, will not tend to affect adversely the use of neighboring property in accordance with the zoning regulations, zoning maps. And finally, of course, they can set special conditions. So it's actually the regulations themselves on 11X DCMR 104, the private school plan regulation. The regulations specifically say, and that's why our argument is that the BZA didn't do its job at actually analyzing its own regulations, that the private school may be located so that it is not likely to become objectionable to adjoining a nearby property because of certain activities and adverse impacts like noise, traffic, number of students, or otherwise objectionable conditions. The number of staff, for example, between MIC operations in their conference center, their staff, and the number of staff at the Levine School was somewhat comparable. There are actually more staff at MIC. So what we're arguing is that simply relying on saying that there's some instruction that takes place opens the door to almost anybody, any residential private residents could say that they host events that are of an instructional nature. Certainly all the conference centers and all the hotels in the district could make the same argument and could justify turning a residential zone essentially into a completely different use or justify a completely different use.
There are kind of two related issues. I know that you, in my mind, you I think acknowledge that we ordinarily will give great deference to the BZA's interpretation of its own regulations. I know there's some dispute in the Supreme Court about how much, whether that should continue to be the law, or if so, how, and there'd be interesting questions about whether we would be affected by any of that dispute. But taking as a given that we need to give the BZA a lot of deference here, what then comes is, let's say it is a little hard to figure out the line between something that is educational enough that you could call it a school and something that you just can't reasonably call a school. If that's a hard line to draw, it seems that we're going to need to give a fair bit of deference to the BZA's, wherever it settles. Or do you agree with those general comments, or do you take issue with some aspect of that set of remarks?
The aspect that I take issue with is giving the BZA great deference to the extent that it does not have to engage in legal analysis at all. And that's what
okay. And that I was thinking of that as almost a second issue, which is whatever deference we're going to give, there are principles of administrative law that require explanation and adequate explanation. And I gather that a part of your point is it's hard to figure out what exactly the line is between a school or not a school, but you think the BZA hasn't adequately explained what it's doing here.
Well, it simply relied on the regulation and the definition alluding to the Webster's dictionary, and in no way even followed the instruction of the court in analyzing the activities on a daily basis as it applies to the application of this definition in the case.
Well, their explanation is private school is not a defined term. The regulations tell us if you don't have a defined term, go look at a particular dictionary. When we look at that dictionary, we see that there's a pretty broad definition. Something can be viewed as a school if it's, there's some learning that happens there. And we're going to pick that definition, and we're going to say that, as we have for the last, 60 years, that at least some of what MIC does is makes it a school, and it's not a public school, so it's a private school. Why isn't that an adequate explanation? What do you think? I get your point that maybe there's an argument that even if that's true about some of what MIC does, it does so much other stuff that there's like a primary purpose test or a primary function test. So I got that thought. That's less an explanation point and more a substantive argument you have about the only way it's reasonable to interpret this regulation. But it seems like a pretty understandable explanation. It just seems as though in part your point is that's just too broad. That's unreasonably broad. if you take that definition, it'll go so far that it can't be what a reasonable regulation interpretation of this regulation is. Am I right? That's a part of your argument.
That is a large part of our argument on the statutory construction, because the way that the BZA interprets the definition is so broad that it allows itself to apply it in an arbitrary manner. That's the whole problem. That by not implying, and I have to point out that the appellees here did not distinguish the Levine School or the court's treatment of that school and analysis in that case, where I understand the special exception was granted, but it's clear that the court didn't simply say, oh, there's some instruction here, so that's it. The court looked at whether or not the school's allegations that it was functioning as a community center actually held water. The school, in fact, provided instruction. It analyzed the number of students enrolled, and it compared it to what other educational institutions might look like as opposed to trade schools. And that's how it was able to determine that it was a school. And so we're not arguing that you abandon the Webster's dictionary definition. We are providing deference to the BZA's interpretation of the regulation in using that definition, but simply saying that the BZA is not empowered, is not allowed such deference that it is able to make arbitrary and capricious determinations.
So
And
if hypothetically this case were remanded and the BZA fleshes out facts that it lays out on page 31 of its decision, page 203 of the joint appendix, where it says, you know, it's a nonprofit organization, it offers educational and cultural exchange programs. If it said it offers 20 such programs a year, it has, you know, 4 instructional seminars per quarter, is that going to satisfy your complaint? I mean, is it just a matter of fleshing out the details, or is it that?
well, in this case, excuse
please,
me,
go ahead.
The reason why that's important is because the BZA is essentially a trier of fact. And we have the opportunity, the neighbors have the opportunity to challenge the veracity and credibility of the applicant and to say, hey, this is not happening. Okay, they're alleging that they have these many events, but this is what we see on the day-to-day. And because that analysis did not take place, there was no balancing of kind of the day-to-day operations of MIC with.
You know, it's counsel, it's a little hard to hear you making that process argument when this argument wasn't raised until after the hearing. I mean,
So,
the reason you didn't have an opportunity to flesh those facts out, I think, is you didn't raise it.
So of course, the neighbors are talking about impacts to themselves, and they did submit testimony, and the ANC did testify and also made this argument after the fact. But this is not, in terms of the day-to-day operations, all of that was in the record. That did not need to come from the neighbors themselves. They are providing evidence about the, I guess, bad faith in dealings with the applicant in the past. But because the BZA didn't consider basically that back and forth and essentially they just shirked the responsibility of truly analyzing whether or not this event space or MIC functioned as a school. And
Can I ask you legally, I get your point that the BZA didn't explain enough, but it also just went too far. It can't be enough that that if you can say about a location, so that, you know, a use at a location, that something educational happens there, that we're going to call it a school for purposes of the special use regulations. I understand that argument, but if we're going to be persuaded by it, it might be important to be able to say to us, okay, here is at a bare minimum what needs to be required more than that. So what is it you think the BZA just couldn't, you know, it's like the bedrock bare minimum that it's just unreasonable for the BZA not to insist on? Is it that at least half of the events by hour are educational? Is it they use the word student to describe who they're dealing with? Is it that it is not commercial? Or, I mean, what do you think the bedrock things are that would have been more in the realm of what would make a definition that the BZA could accept within the realm of reasonable ones?
Well, I think we would encourage the court to instruct the BZA to analyze factors. So there are a number of factors. For example, when we look at the Levine School, they looked at whether or not individual or classroom instruction was provided. They looked at whether or not they did outreach to students and how they did that. They looked at how students presented themselves in activities to the community. They looked at national associations that the school was associated with, like the National Association of Schools in Music. So these were all kind of measures that the court was able to take to assess whether, and it's not any one of those things that would be definitive as to what on the question of the school, but cumulatively to be able to analyze that point of law. And we would add one additional thing, and that is that the appellees also brought this out in their brief. They're not even arguing that that MIC would be under the regulations using the property as an educational use. And in fact, they distinguished. They said it's not really important whether or not the term educational use applies here, because that's not the word school. Well, you know, that would be one useful thing that the BZA could do, is look at other sections of the regulations and see how education is treated in analyzing these.
Yeah, I'm interested in that answer, because you did cite another, I mean, although private school is not a defined term, private education is a defined term. And but that definition, it's a little unclear to me, but that definition seems like it might exclude the Levine School even. And so it seems to say an educational, academic, or institutional use with the primary mission. So that might be some guidance about how important the educational uses have to be relative to other uses. Of providing education and academic instruction that provides district or state mandated basic education or educational uses. And if it has to be district or state mandated, I mean, with the Levines, there's no legal obligation mandated by the district that kids get, or even kids or adults get music education of the kind they get at the Levine School. So I'm wondering whether if that definition were carried over, it would have some pretty significant consequences, including meaning that the Levine School case was incorrectly decided.
Well, we're not arguing that that definition should be applied here to the T, but simply that it should be used, at least considered, in analyzing whether or not educational activities take place and to what extent the institution is in fact a school. So we do believe that the statute and the regulations provide the guidance that would be necessary for the BZA, and that the BZA's regulations can be consistently interpreted, but that with the BZA kind of refusing to adopt any kind of test here, besides just alluding to the Webster's Dictionary, it seems like those tools are just not being used, and therefore the purpose of the BZA in ensuring harmony and trying to mitigate against adverse impacts in neighbors, also in pursuing the goals of the zoning regulations and the zoning laws, they're basically not being upheld. So unless there are other questions about the school argument, we did raise a bunch of other issues in our brief related to statutory construction and regulatory construction, just in terms of how people should be able to understand these regulations. But again, we don't think that any one particular factor needs to be dispositive, but for purposes of consistency and to avoid arbitrariness, the BZA should be employing a test and using it when it decides applications like this, even though it didn't do so here. Then we wanted to turn to the second issue, which is on...
I'm sorry, just so I give you a chance to articulate it. And what is the test you think they ought to be applying?
a test that examines the day-to-day operations of the school, looking at whether
That's
there's
not a test. That's a mode to looking at whether or not a test is satisfied. So what is the bar that you would have the BZA measure this against? Put aside the process. Put aside, how the various factors they look at. What's the question at the end of the day is just the basic. Is it a school without rounding? You don't have any more you want to layer into that.
Well, of course I do. That one particular question is just dispositive because it doesn't get the special exception if it does not function as a school. And as we discussed,
I guess I don't find the question so meaningful. I mean, I don't know, I don't really know what that means. So what are we to look at to try to flesh that out? What sources can we look to say, it needs a student body, it needs a faculty, it needs classes on a daily basis? I mean, where would we derive those types of requirements for? Or are you just saying it's kind of a field test, it's a totality of the circumstances, and you feel it out and you give deference to the BZA and their attempt to feel it out?
I was arguing, honestly, what I thought was less controversial, that it would be something like a totality of the circumstances test, where the BZA would have to take into account all of the facts on the record and apply it here. And I don't think that there's one or another factor that's dispositive on whether something is a school, but seen in the context of the purpose of the zoning regulations, the school should be functioning to a certain extent consistently with the way that educational use is used by the regulations in other places. Not necessarily requiring to the T every single requirement, but at least consistent with the spirit of those rules in order to.
So can I just to get a sense of like where you would, totality of the circumstances test, it can be amorphous, and so it can be hard to get a sense of what it is you have in mind. It can help a little bit if, for example, if I started up a for-profit company where I had all day long, I have people who I call teachers come in and teach what I call classes, and people pay what I'm going to call tuition, and that's the only thing I do. I'm for profit. Does it depend on what my subjects are? Does it depend, if that is my model, those are my labels, and what I'm doing is teaching. Teaching sculpting. I assume that's like the Levine School. That would be okay in your view? Let me
just extrapolate that one step further. To me, that sounds okay. But if it's taking place on top of a condo building, or let's say it's taking place in my single family home, and I would like to build a large conference facility in my backyard because I have programming at my institution, and I believe that would be of benefit to the institution. So the point here is that it's not just the functioning; it's the zoned use. And
I understand that, and I understand your idea about primary use, but just a slightly different hypothetical. Imagine instead of sculpture or music, I'm running what everyone would normally think of as a gym, but I call it a physical education center, and I call the people who come, students, and I call the staff who work with them trainers or faculty, and I have spin classes and I have yoga classes, and I say that's just my physical education school. Would you say that's fine, or would you say, look, on any reasonable application of the multi-factor test that you have in mind, that would be on the wrong side of a reasonable outcome?
That would be a gym. It's interesting. It's an interesting question. I would look forward to seeing the way the court would treat a case like that. But I think here, obviously there is no bright line rule that's going to jump out saying, oh, that is a school. I mean, at the top of my head, I'm not personally aware of any physical education school that exists. but maybe I just haven't heard of it. Music schools, however, are fairly common, and the court did address that in the case. So maybe that example would be a little bit different, but I think the point is that you have to look at the use that is already zoned for the property. You have to look at the daily operations of the institution. You have to look at the definition, and you have to look at the impact to a certain extent in order to analyze whether that institution is functioning enough like a school so that it would not be disruptive to the community.
Counsel, I apologize because you were trying to move off the school discussion, which we spent a lot of time on, to get to some of the other, some other points. We're already over time. I do want to give you at least a couple minutes if you want to pick, what your main remaining point that you'd like to make sure you get a chance to say some things about, and then we will give you your time in rebuttal.
Thank you. Yeah, I mean, just to point out a couple of issues on the affording or lack of affording the ANC 1C great weight in her concerns and the impacts. It is our position that it's clear that listing off the concerns is not enough. They have to actually be addressed. And so stating that that the ANC had a concern with traffic or had a concern with noise or had a concern with the comp plan and simply dismissing it by relying on an MOU that actually may or may not be enforceable.
Counsel, can I ask you a question? Just it might help me. When I feel like a lot of what the BZA said in response to the ANC concerns, if I'm remembering right, was they can do more noxious things as a matter of right with regard to traffic, and they can do more noxious things with regard to the height of the building and the density of the building. So you don't really have much of a complaint with what they're doing. The complaints that you have are things that have nothing to do with the exception that they're seeking, because they could do all that anyway.
That is what they said.
What's wrong with that?
That's why I was going to start with the quotation from Miss Fox Perry, where she says directly to this point, quote, "The other thing too is that we're being told, look only at the conference center and not at the 111 unit condominium building, because the building is by right. The components of this project, however, are inseparable from each other. You've got the motor court, the parking garage. They're all going to be shared. It is really impossible to separate them, and that the burdens, the impacts from both should be considered." And so that is our point there, that yes, of course, there is a matter of right, but we're not talking about conceivably what the applicant could do in another hypothetical world. We're talking about what they're planning to do and the actual concerns that neighbors, as represented by their elected official, ANC, voiced. And so that's why it's, as a matter of right, it doesn't discount the concerns that they have, because actually the conference center is a huge portion of this development. As MIC explained itself, the reason for the condominium building is to support its operations. Its operations are of the event planning type, or of the event space that we discussed earlier. And so these two facilities are joined. So it is impossible to say what the actual impact would be in some other plan that would allow, lower density residential housing across the entire piece of property, because that's not what's presented before us. And that may be completely impractical given the fact that there are two national historical landmarks on the property as well. And I just want to say in closing, because we are over time, that we did deal with, and there was some confusion or back and forth, I would say, in the briefs about the issue of the comp plan. And it is not our position that the BZA implements the comp plan. We did not argue that in the brief. Simply, we argued that it is actually the ANC's obligation to look at planning documents of the district. And she, in her job, in her responsibility of analyzing the impacts of this project, looked at the comp plan and identified discrepancies. And the BZA did not deal with those discrepancies, understanding that it's no expert in the comp plan. It could at least have answered those concerns. And it just did not. And it's our position that that cannot be great weight, to simply ignore the impact by alluding to either an MOU or that may or may not actually be enforceable. And there's things that I can raise. We brought them up in the brief about why those MOUs were problematic. For example, one of the parties didn't even exist at the, for example, the condominium association doesn't exist. So we don't know how we would be working with them or implementing that MOU. And then finally, on the comp plan, that we have a right as district residents and the neighbors to look to the future of what DC is going to look like and what that neighborhood is going to feel like living there with this additional conference space and with this additional large building that changes the landscape. So it is not affording great weight to simply dismiss concerns, valid concerns that the ANC presented by alluding to the zoning commission's decision when you go to the zoning commission's decision on this point and it doesn't address the substance of the matter.
All right, thank you, counsel. We have your argument. We'll give you 4 minutes in rebuttal, if I recall. That's what you asked for. And we'll hear now from opposing counsel.
Good morning, Your Honor. May it please the court, Deborah Baum on behalf of the intervener, MIC9 owner LLC, on behalf of the Meridian International Center. I'd like to address initially our standing argument. As the court knows, we moved to dismiss the case altogether on the basis of standing and for summary disposition in response to the petitioner's motion for summary reversal. On the standing point, the analysis that Judge McLeese laid out in the opinion of the DC Library Renaissance case gives a fulsome discussion and analysis of the District of Columbia law on constitutional law on standing. And I think this case stands quite in stark contrast to the DC Library case. And specifically, for standing, under this court's jurisprudence, there must be constitutional standing, which requires an injury in fact that has to be real, concrete, and particularized. And that injury has to be fairly traceable to the challenge action. And third, it has to be likely redressed by a favorable decision in this matter. Second, with respect to prudential standing, petitioners can't litigate generalized grievances. And there's a very helpful zone of interest analysis in the DC Library case. I think in this case in particular, though, I'm not challenging the zone of interest per se, but the injury here that's alleged is in stark contrast to that in the DC Library case. There, the petitioners claimed that as a result of the decision they were challenging, their library was going to be closed, and they said the new one was going to be inadequate. It was concrete, the court held, and particularized. The issue here is that it's much more analogous to the claimed injury, if you will, in the York Area Tenants Association case, where the court held that there was no standing.
But I mean, if I remember that Utah case correctly, it was sort of this very vague, quiet enjoyment of our homes without putting any meat on the bones. And here we have, there's going to be a lot of very noisy construction. There's going to be an increase of traffic. It's going to be more dangerous to traverse this street, and possibly somebody could get hit. We live right next to it. That seems like an awful lot of injury that would be very, very well redressed if this exception were not granted to them. So, I mean, it looks like the Union Market case to me, and I guess I don't see what you're pointing to as the difference between this case and that for standing purposes.
Well, Your Honor, thank you. I'm focusing more particularly in this case on the prongs that require, I mean, even I think that this injury that's claimed is actually more akin to the York Area Tenants Association, because if you look at the specific injury that these particular petitioners claimed in their letters that were sort of boilerplate, all almost identical to one another.
Because they all live in the same building, they're all going to suffer from the exact same harm. I mean, it's not a surprise that they all have the same complaint about a lack of parking in the construction. I mean, I'm not to speak for any other member of the panel, but you know, I don't think you really have a leg to stand on standing. I'm curious to hear about why MIC is a school. That's what I'm more interested in.
Okay. May I just make one point with respect to standing then? Understanding and respecting Your Honor's view on that. I think the point that I'm trying to make on standing here is that, and it's related to what the Petitioners Council was talking about at the end of her argument, which is their concern. And if you look at, I'm just reading from the letter. This is, I believe it's at the joint appendix at 405, or record 405, I apologize. They say the project, which will add more than 110 units of residential housing at the conference center, and I quote, will create an undue burden through the influx of residential and construction related traffic, loss of parking, and an inevitable increase in noise and congestion. And the noise and congestion was akin to what was claimed in York Area Tenants. But more importantly, the focus was on, and the identified impact was the influx of residential and construction related traffic. And the important point here is that those two issues, the residential use is not being challenged, it's a matter of right. So that would not be redressed here. It's not fairly traceable to the challenged action here. It's not traceable to this being a school or not. And second, construction is legally irrelevant under the St. Mary's case, and the BZA addressed that point particularly at Joint Appendix 190 in the order. So under this court's decision in the St. Mary's case, you can't look to the impacts of construction because construction is going to happen in any development. And my point here on standing is simply that these particular petitioners were citing injuries that they claimed would be the natural outgrowth of this residential project, and construction related activities is what they were focused on in talking about these particular impacts. So we submit that that's not tied to the challenged action and not likely redressed by a favorable decision. But understanding the court's perspective and interest on the school aspect, I listened with interest, of course, to the arguments of counsel with respect to the school issue. And it's a little bit ironic, and I would submit procedurally unfair to say you didn't even flesh this out at the hearing when, Judge Steele, as you noted, I was thinking the same thing when that argument was being made. This issue wasn't even raised by anybody until their post-hearing briefs. So it wasn't fleshed out. It wasn't the subject of a lot of testimony the way it was in the Levine school case, which is the subject of the
Counsel, on that point, are you arguing that we should just not review the BZA's ruling on the merits on that issue because the issue was defaulted as not presented before the BZA? Or are you making a somewhat more limited kind of, when you're trying to take into account the reasonableness of the discussion of the BZA, you should factor in when it was raised? Because if you're raising the former, there is a complication, which is the BZA itself did not treat the issue as defaulted. It decided it. The BZA said, kind of observed, well, it seems like it was kind of belatedly raised, but it didn't actually say, it's defaulted, we are rejecting it on that ground. And we're ordinarily not in a good position to affirm an administrative agency on grounds that the agency itself didn't rely on. So I just want to be clear, are you asking us to rule, doesn't matter whether the record right now supports the idea that this is a school, and it doesn't matter whether the BZA adequately explained all of that because the issue is just defaulted and should not be considered on the merits, or is your argument more limited?
The latter, Your Honor. We did not make that argument. We didn't think it would be appropriate to. The BZA did consider it, but it is rather, as Your Honor more eloquently than I can stated, the BZA, you have to take into context when you're talking about what's in the record, the fact that it wasn't raised until the post-hearing briefs. But the issue here is that counsel made a lot of arguments about how one should look at school, what a school is or what a school isn't. The fact of the matter, though, here is, if one is a school, if a use is a school use, there are a whole host of regulatory requirements that go along with that. So I think that's probably, as a practical matter, why you don't see people clamoring to be treated as a school, because then you have to go through the special exception process and make all kinds of showings, which was done here. But the bottom line with respect to the regulations that are on the books now is that there is no definition of private school. And the BZA regulations say where there's no definition, you look to Webster's dictionary. They may not like the Webster's dictionary definition, but that's what the regulation says. You look to the Webster's dictionary definition. And the Webster's dictionary definition is very broad. And it says a school is, quote, an establishment offering specialized instruction, close quote. Now, if there was
counsel, can I just test that for a second? I assume if I were to go get a job at McDonald's tomorrow, they would have to provide me some instruction on how to work the cash register, on how to keep the assembly line moving. In your view, is McDonald's a school?
If McDonald's wanted to come in with a purpose of offering instruction on, if they had a special facility on how to training their people.
We've got a 1-week training program for all new employees, and we instruct them on how to do, use the fryer, how to flip the burgers, how to use the drive-through. Let's say they've got that. Is that a school?
In theory, Your Honor, if they wanted to submit that they were a school instead of a by right use in the commercial zone, I can't fathom why they would want to do that. Under these definitions, in theory, they would.
So is my house a school if I have a book group once a week where, we, a group comes in and we, back in the day when we weren't doing things remotely, people came and we talked about books and we mutually educated each other about books once a week. Or just to give you another piece of the hypothetical, my children don't live at home with me anymore, but when I had children who were living at home with me, my wife and I certainly thought that a big part of what we were doing with our children was educating them about a lot of things, about how to behave and many, many things. So was my house a school? Because a lot of what was going on there, if I was doing it right and as I was trying to do it, there was a lot of education going on there.
And I like to think I did that with my children in my house too, but I don't think I would call my house an establishment. And this definition talks about an establishment. And again, as a practical matter, if the floodgates opened and everybody wanted to be treated as a school, I can't imagine why they would, because again, it carries with it a whole host of regulatory requirements.
Counsel, I don't think Judge McLeese's or my questions are getting at sort of a practical concern. I think they're getting at a more linguistic concern of what we mean when we use the word school. And let me run down a few things that I think of when I think of a school and get your answer to them. How many teachers are on faculty at your school?
I don't know that off the top of my head. They offer instruction. It is.
Do you think the answer might be?
Is there anyone even called a teacher? Yeah, is there anyone called a teacher or instructor who works at your institution?
I suspect they're called instructors.
I'm sorry, does the record indicate whether there's anyone who is labeled an instructor whose job title is teacher, instructor, or some word that makes you think of education?
I don't know that off the top of my head, but I will.
Yeah, and I understand. I mean, again, there's a fairness point here, which is you didn't really know that you were going to need to develop a record on this. And so if the court, I think that at a minimum, if the court has further concerns about it, there would be a remand where you would have an opportunity to create a full record if there's any concern that there needs to be further proceedings. So I get that point, but just in terms of, the BZA concluded that the current record was enough to establish that this is a school. And so I apologize for interrupting Judge Steele. He was asking a question about faculty, but he had some others that are similar to ones I was thinking of. Like, do you have, are there any payments that are called tuition? Are the people who come and get educated called students? So there are all those questions. And are the events called classes? What are they called? If they're called conferences, what does that mean? Those all seem potentially relevant if you're trying to figure out whether it's just a reasonable thing to call a school linguistically, or maybe in a regulatory way. So that's, and I don't mean, again, I kind of jumped into the middle of Judge Deal's question, so I want to make sure he gets back in. But the related piece of it is also,
I have the same questions.
Yeah, but the other piece of it is that your opponent is making an argument, and made an argument in front of the BZA that is along the lines of there has to be some quantitative inquiry too. And so if I call, and this Judge Deal's original hypothetical was about that, if most of what I do is running a McDonald's, but once every 2 months I train new employees for a half hour and I call it a class, and I have someone whose job it is to go around the country, who's called, the teacher, and I call the people, trainee students. That feels like it's educational, and the line between it and the Levine School is hard to draw. But if it is a fragmentary piece of what is mostly being done there, whether you call the establishment as a whole a school linguistically or as a reasonable regulator seems a harder question. And your opponents in specific argued that that's true about what's happening here, in that even if the conference activities, some of the conferences are educational in character, over half of what's being done by event counting is private events that, maybe I've gone to weddings where I learned things. So maybe you could think of a wedding as an educational event, but it's a pretty, that gets even more expansive on what is or is not educational. So that's a lot together, but I'm interested in your thoughts about the adequacy of the BZA's explanation, the extent to which you would carry all of this, and the extent to which we might need to know more facts.
Well, Your Honor, the BZA, again, this was not a focus of a lot of evidence submitted at the hearing because nobody raised it. This use has been characterized by the BZA as a school since 1960 through a series of decisions. Now, the court in Tiber Island said, and there's a whole body of case law, the Court of Appeals, saying that the BZA can't arbitrarily, without process, change its interpretation of its own regulations.
But does that bind us in some way? If the BZA has called it a school forever and we've never said, actually, yes, this is a school, then what effect does that have on our review? If the BZA can't turn on a dime and change its mind, the first time it's brought to our attention, as far as I can tell, we've never said anything about whether or not MIC is a school. Are you suggesting that we're bound, that this court is bound by a past BZA interpretation?
I'm not suggesting that this court is bound by a past BZA interpretation at all, but rather that this court is bound to defer to the BZA's interpretation, and also bound by this court's precedent that says the BZA can't change the way it interprets something without process and explanation. And so, frankly,
right. Although if there were a remand, process by way of evidence would be available. But can I ask you about your practical point? Because when Judge Deal and I have asked some questions that reflect some concern about, wow, this could be a very expansive concept of school, and almost anything could be viewed as a school if all you're doing is requiring non-zero educational activity in some respect. Your comment, one line of assurance you give us is, well, practically that's not a problem because it's really not that great a deal to be a school. Most people won't want to be a school. So on the other hand, MIC seems to want to be a school for purposes of this. Are you saying we would be doing your client a favor if we say, give it up, don't be a school anymore? That's hard. Your lawyer said that's harder than not being a school. So we'll give your lawyer the request of making your life easier by not having you take on the difficult burdens of being a school. I assume that's not what you want.
No, Your Honor, of course it's not. My point there was simply in response to what I understood to be the court's question, saying, couldn't this really open the floodgates, and my house could be a school and McDonald's could be a school? My point was simply, as a practical matter, I don't think we've ever gotten there. If that happened, I suspect they'd probably change the regulation. But what we're looking at right now is a regulation that says, look to Webster's. And Webster's says, an establishment offering specialized instruction. No one has ever thought to change that, obviously. because it hasn't become an issue, because for precisely the reasons I described, there aren't people clamoring to be treated as a school. But in terms of what's on the books here, I would admit that if in fact the BZA had said, well, I'm going to apply some kind of a test that says you have to be at least X, and I think you probably have to defer to them anyway, but there would be an argument that that was actually contrary to what is on the book. The definition, there is no definition of private school. The regulations clearly say where there isn't, look to Webster's. And what Webster's says is an establishment, not a home, establishment, which I think is fairly read as some kind of an institution, offering specialized instruction. Now, in the record in this case was Meridian describing its core mission as educating leaders. That's its core mission, educating leaders. People educate, as Your Honor noted, we educate our children at home in one way. People educate in a whole host of different ways. And I don't think it's for the court or the BZA to say how to dictate, and they are not purporting to, how education must take place or what you call the instructors. The definition in Webster's speaks to instruction, and that is the part of the core mission of this establishment.
Could I ask you if you have an answer to the question that I asked your opponent? Let's assume that we think a private wedding is not educational, and I don't think you all have argued that the private weddings fit within the definition. What regulation says that if you're a school and you are allowed to be where you are because you're doing educational things, you can do some non-school things there? I know there's some definitions of what things are school things, like, you know, sports facilities are school things because they really are educational. But what regulation do you think governs non-educational, non-private school uses of a special exception establishment that is, assume it actually is generally appropriately viewed as a school? Is there a regulation that you would point us to that tells us that that's allowed at all? And if so, how much of it is allowed?
Well, I know, for example, in the public school definition, it talks about, you know, ancillary uses that are often associated with schools. It's not just the educational. I don't have the regulation right in front of me, but I know there's
I'm familiar with that regulation.
That sweeps that kind of thing in. And frankly, in the earlier orders, I think it was the 1960 order, one of the conditions was that the number of dances, for example, be held to a number that's comports with what is normal for schools and universities at the time. And so, you know, there are a whole host of schools that are subject to extensive regulatory frameworks under the zoning regulations, colleges and universities. And there are concerts, there are weddings, there are all manner of things that happen there because, exactly as Your Honor pointed out, that's all part of the educational experience on the one hand, and frankly, as a practical matter, those are nice venues people like to use. And so that is something that is specifically addressed in this order. The BZA took it on head on, and the way it did with the other concerns raised by the ANC, I would respectfully disagree with my opponent with respect to the care and attention that the BZA showed to the ANC's concerns. It walked through each and every one of those concerns.
Can I ask you one? I know Judge Steele may have additional questions too, but there's one area that we haven't discussed yet that I think it's briefed in part as a component about giving adequate weight to the ANC, but to a degree it's a discrete point, which is to what extent in fulfilling its regulatory function is the BZA permitted to or required to consider comprehensive plan elements and zoning maps and all of that? And I found that very confusing. The BZA said, not our job, and cited some of our cases that seemed to say that. But your opponents argue that those cases are out of date, that in fact the zoning regulations and the comprehensive plan have been amended in ways that make it quite explicit that the BZA needs to be taking those things into account in various ways. And that there are also some of our cases that now say the BZA is supposed to be looking at this, that, or the other thing. So I found that all very complicated, and I'm curious what your response is on the topic of whether the BZA was correct to say, when we're figuring out whether, you know, the specific requirements of 901.2 have been met, we don't need to think about the comprehensive plan. I mean, 901.2b itself says, refers to 901.2a says will be in harmony with the general purpose and intent of the zoning regulations and zoning maps, which I assume are like the generalized policy map and the future land use map. But then there's some other provisions that are cited that expressly say either authorize or seem to require the BZA to be thinking about, like, what does the comprehensive plan show that people care about in planning? And if someone is saying, I want a special exception, and you're trying to figure out as a BZA, are there adverse effects? Well, let's look and see what the comprehensive plan thinks is important. And if it's undermining the comprehensive plan, then that might be an adverse effect. So can you just shed a little bit of light on whether you think the BZA was right to say, you start saying comprehensive plan and we start zoning out, no pun intended, because that's not our job?
Well, I'll try to shed a little light on it, Your Honor, but it is complicated. But to the extent that there are decisions cited with respect in the briefs, particularly with respect to this issue, it's because this court decided in 2019. So it's hardly out of date to the extent that our adversaries have suggested that. The Citizens for Responsible Options case was decided in between the decision by the BZA in this case and the briefing in this court. And that case specifically says that the BZA does not have authority to implement the comprehensive plan. The regulations say that the BZA may, and this is what counsel for the petitioners latched onto, the BZA may consider and cite to consistency with the comprehensive plan as one of the bases for its granting an application. So it certainly may look at it, but the BZA correctly cited this court's authority, saying that it did not have authority to specifically implement the comprehensive plan. So our point in our briefs was this is not to say that it is irrelevant to the process, because the Office of Planning is a body that is tasked with interpreting and applying the comprehensive plan. And so, in fact, in its report, which it submitted to the BZA and to which the BZA is legally required to give great weight, the Office of Planning does consider the comprehensive plan and consistency with the comprehensive plan. And so in this case, to make the record even stronger, the BZA said, we hear you on the comprehensive plan. We're without authority to actually implement the comprehensive plan. That's not our job. However, here are the issues that have been raised: traffic, parking, noise, etc. Those are all land use criteria that are woven into the comprehensive plan, both in the future land use map and other aspects of the comprehensive plan. And then the BZA meticulously walked through each and every one of those. So while it essentially said, not our job, it didn't stop there. It went on to carefully walk through page after page after page of discussion of precisely those factors.
And are you drawing a distinction in that answer between implementing the comprehensive plan and considering it?
To some degree, yes. It's certainly not precluded from considering it. And the regulations specifically say it may look to consistency with the comprehensive plan and supporting its decision.
Well, one of the regulations, 10A DCMR 2504.5, says require the BZA to look to the district elements of the comprehensive plan and its accompanying maps. So I think they're not all just permissive. Some of them seem to be, and then that's the word is look to. So I'm not sure where you fit that into a spectrum if you're creating a spectrum between implement and consider. But
well,
that seems. Are you familiar with that regulation, or do you think that it's not mandatory, or do you think that regulation is inconsistent with our case law, or how would you respond to what that regulation seems to require the BZA to do?
I think that the regulation, look to is different from, this is the criteria. I think look to is consider, certainly, and they did consider. But the decisions of this court have said the BZA is without authority to implement the comprehensive plan and to basically enforce it. The body that has the authority to do that is the zoning commission. The zoning commission can do that. And in fact, in this case, as the record shows, the petitioners had the opportunity to, and you can go to the zoning commission and ask for relief. But that it's the zoning commission that has, in the land use framework in the District of Columbia, the authority to actually implement the comprehensive plan. And the BZA may consider it, absolutely may look to it, and did, and analyzed each and every piece of it. And again, this is one of those arguments where on the standing point, I come back to there's just no connection here between whether the relief sought would in fact regress the alleged injury, because in fact the BZA has already gone through every single piece of those land use factors, every single one of those land use factors.
Thank you, counsel. Again, unless Judge Hill looks like he may have a question.
I just have, really, it's not so much a question as if I want to give you an opportunity to see if you can provide any record sites for things that might answer some of our questions about whether or not this is a school. So like what I've been able to find, which is from the application and it's around elsewhere in the record, is 4 times a quarter you hold events, once a year you hold what looks like a big gala. As to who's teaching those events, who the students are, if they're tested, is it the same or is it just a rotating group? Is there a citation in the record? I didn't see anything answering questions like that. If you want to point me to anything, this is just an invitation to do that.
Thank you, Your Honor. I have, I'm looking now at page 178 of the joint appendix. And this is page 6 of the BZA's order. I don't have the sites back to the record on which they are relying at my fingertips, but where this particular part of the order, and I'm starting in paragraph 12, the order talks about Meridian being a premier nonprofit global leadership organization that offers educational and cultural exchange programs, etc. Paragraph 13, Meridian's programs include experiential learning via tours and activities in other cities, as well as various training programs, expert panels, and related events hosted, etc. And then paragraph 14 has more detail on that. If the court would like, I would be happy to submit record sites to the evidence that supports those findings of the BZA, but the BZA did make those specific findings about the educational programs, and they say that they even include work with the DC public schools. So,
no need from my perspective. I mean, the things that are in the BZA opinion itself, I'm not questioning. So I don't have any need for further record citations as to those facts.
Okay, thank you very much. I know my time is long up, and unless the court has further questions, I will submit and respectfully suggest that this court, because the issues are so plain on the face of the decision, the BZA's decision, that we submit that it was appropriate for summary affirmance. Thank you.
Thank you, counsel. We'll hear now from counsel for petitioners. You're muted.
Thank you, Your Honor. A new challenge. So just to get to the point here on the issue of the school, I'm not going to go back and forth again, but I mean, I think that Your Honors understand that we have great concern with the ability of the BZA to consistently and non-arbitrarily apply that one sentence from Webster's dictionary. And again, we're not disputing the fact that the regulations adopt the definition. It's simply that it's the BZA's job to apply the definition. And you
right. It seems quite easy to apply consistently and non-arbitrarily to me. Everything's a school.
I guess I guess if everything's a school, then everything is also not a school at the same time. And the term school means nothing. But and I guess that makes it very difficult for neighbors to know how to address these types of applications. But yeah, it's something that should have been explored at a minimum. I do want to then go to the issue of impacts because I didn't spend a lot of time talking about that. And Ms. Baum brought up the fact that there were some impacts that were raised in the testimony that she's arguing are not fairly traceable to it being a school or to the relief sought. And it's very clear when we started this argument, I pointed specifically to that passage, that portion of testimony that indicates that this is fairly traceable to the school, which is not only building a new conference center, but despite its assertions that it's not really going to be augmenting operations at all, it is adding a conference center. It is an additional conference center, whereas now all of their operations are in the mansions. That's what the applicant is saying, that they are going to build this building to relocate the parking garage, to redo this entire scheme and to factor in this new residential project. So it's not that the impacts are only traceable to something that's available by right, and I'm going to discuss that in a moment. But the project itself is intimately tied with the expansion or the addition of this new conference center.
Can I ask you a question about impacts? It's very detailed, and it just popped into my head, and I don't remember the record clearly answering it, though that doesn't mean it doesn't. I just don't remember it. I know there was an assurance that the number of events was not going to increase as a result of this. Was there any assurance about the magnitude of any particular individual event? That is to say that if they now have a certain amount of conference space and they'll have more, does that mean that they might still have 50 events, but they'll be able to invite more people more often? Or I know there are caps on what they can do.
There are caps on how many people can be there at any given time. There are a number of requirements, but my concern and the concern of the neighbors and the concern of the ANCs has always been that this applicant has a bad history with MOUs. And we don't even know who we're dealing with when it comes to some of the people that are supposed to enforce these MOUs. So we would have wanted, and when we raised in our brief, for some of the conditions to be integrated into the decision, for them to be conditions of the BZA's order, but they're not, and it relies on this.
Did you ask the BZA for that?
You mean at the proceeding below?
At any point?
One moment.
And while you're looking for that, I'm right that some were, not all were, but some of the MOU agreements were actually incorporated as part of the order here. Is that right?
Yes, some were.
But not all. But not all.
So yeah, I mean, it's not.
And I didn't mean to interrupt. I know you were about to try to answer Judge Steele's question. I apologize again to Judge Steele, but I just wanted to clarify one aspect. But do you know whether it was made explicit to the BZA by petitioners before the BZA ruled, we want the MOU in total to be incorporated into, or in critical parts that weren't included, to be included in the whatever order you issue if you do approve, which we don't think you should do?
What I can find, and what I can, if it would be helpful, I can file this afterward too, a list of record sites. My understanding is that they presented certain aspects of the MOUs that were actually useful. But the ANC, in her testimony and after the fact, also addressed the problems with the MOUs and the fact specifically that with enforceability and not only related to the MOU, but the fact that the whole process basically relies on good faith when these petitioners have been trying to work with this applicant for many years and abiding by MOUs. And the testimony shows and the record shows that they have consistently violated those. And so here, the petitioners are really saying the conditions that we understand to be useful, I could find the site. I don't have it available right now as to where this came up in the hearing. My understanding is that they would have wanted them integrated into the order. But simply referencing the MOUs raises a variety of issues that Ms. Fox-Perry also raised. In particular, we can look to the Department of Planning report here, and we cite this in our brief, where in analyzing the impacts here, the Department of Planning basically relied on, the report did not assess MIC's operations or otherwise indicate that any attempt had been made to determine whether the operations were appropriate or the impacts. And then also—
Counsel, I think we're well over rebuttal time, and I'm not sure now is the time to start getting that far into the weeds. So I think we have your arguments and everybody's arguments. We appreciate the arguments of counsel. I'll give you 15 seconds if you want to wrap up in a sentence, but then I think we'll wrap it up.
Okay. Again, I am happy to file that if it would be helpful. Just on the point of impact, again, opposing counsel raised the issue of construction traffic. And we would argue that the law on this is that construction impacts are relevant when harm will result from the structure as built with the zoning relief. And as we've been arguing, this structure incorporates expansion of MIC operations. So we don't believe that that argument really holds water.
Okay, thank you, counsel. I think we have your argument. The case will be submitted, and we will now, I think, be adjourned, if I am understanding our situation properly. Thank you, counsel.
Thank you, Your Honor. Thanks to the court.
This court is now adjourned.